court rise if able.
Mr. Green and Mr. Davis, before you resume, it seems to us that we should make explicit what I referred to obliquely this morning about whether the preliminary issue asks the right question in relation to being willing, ready and willing, and whether actually the relevant question for specific performance isn't that the innocent party has to be ready and willing not at the completion date, but at the date at which the order for specific performance is sought. That appears to be what is suggested in Snell.
I was going to hand that up to you.
Now, we have been proceeding on the basis that since this was the question that was formulated and which was decided by the judge and on which permission to appeal was granted, it is the question which this court must address, but it does perhaps gives rise to some of the conceptual difficulties we've been talking about in relation to how much time you may have to get ready. Now, do you want to just identify the relevant part of Snell? But if you've looked at it,
well, the passage I was looking at was 17038.
Yes.
And in particular, the reference to Davis and Spalding, and the relevance of that to the issues here. I don't know if Mr. Davis has seen this.
Not that, they've given me a different passage in Snell in relation to a different point.
No, I haven't. It's 1738.
Oh, right, sorry. I thought there was a different one. But can I address the point?
I mean, the key point, just to make it plain, is that having referred to the test for specific enforcing a contract, having to show that he has performed or has been ready and willing to perform all terms and conditions, brackets, apart from trivial ones, then to be performed by him as the first element. But then it says, where the defendant is repudiated and the claimant is elected to keep the contract alive and enforce it, it is not incumbent on the claimant to show that he was in a position to complete, e.g. if he is the purchaser, by having the price available, during the period from repudiation by the defendant to the date of the order for specific performance, as long as he was in such a position at the date of the order. Which means that on your claim specific performance, you don't need to show that you were in a position to complete on the repayment date, but that you would be in a position to complete by the date of the order for specific performance, provided that is, of course, that you could establish that there was a repudiation, that there had been a repudiation.
I mean, that's absolutely right. I don't know whether the sensible thing for us to do is to get to the end of these submissions and then perhaps we have all a 5-minute break and we can decide how we want to deal with it. I mean, whether, for example, we might want to reformulate the preliminary issue. I mean, is that what my lords are suggesting?
no, it's not what we're suggesting at all. We at the moment are provisionally of the view, which is why we've, notwithstanding that we were aware of this point before the appeal started, we are provisionally of the view that, as I've indicated, the issue has been formulated, it has been decided by the judge, permission to appeal has been granted, and it is not open to us to reformulate the issue. But we've raised it explicitly as well as obliquely this morning because it illustrates some of the difficulties of the arguments, which may be being put forward on a completely false basis.
Is it helpful if I state our position, at least in relation to that, which is that We would say that obviously this is an appeal against the answer to the preliminary issue.
Yes.
And the court feels that that answer is wrong, should say so. And then the consequences of that would all be a matter for the commercial court, because you'll have seen in my reply skeleton, they have now pleaded in a reply, which is not before this court, I'm not saying it should be, but they have now pleaded that even if they weren't ready and willing on the 26th, they're still entitled to specific performance. So they've now tried to introduce that argument below.
I haven't spotted that.
And I've said in my reply skeleton, we reserve the right to say that's abusive, given how the preliminary issues proceeded. So that might be a way to proceed for the Court of Appeal to say, well, we don't agree with the judge's answer to the preliminary issue, and it should have been no, but the consequences of that are all now for the commercial court.
The slight difference I see with this is that a lot of the argument and the judge's decision is predicated upon the position that your clients were in repudiatory breach. And certainly Mr. Green's arguments, and he started off by saying, well, look, we're in a position here where Mr. Textor has said, I'm not going to perform. And so therefore, what is our obligation in that context? But that is all premised then on the basis that there's a repudiatory breach. And there is no obligation on the Iconic to be ready, willing, and able to perform on the repayment date. And so, to say that's why I asked you, Mr. Davis, or put it to you, that we have to look at that. We should be looking at this on the basis that there hasn't necessarily been a repudiatory breach.
Yes, I mean, I've essentially accepted for the purpose of argument that at most is a repudiatory breach unaccepted, and therefore a thing written in water.
But but a repudiatory breach unaccepted is what Snell is talking about, because if it had been accepted, there'd be no question of.
But I mean, obviously, I'm not ready now to argue a new point about whether that Snell extract is actually correct. The judge at paragraph 38 said something very different, and I showed you that earlier, paragraph 38 of the judgment, where he refers to Forrest and Son, the Forrest and Son case. He said, in these circumstances, if Iconic is to succeed in claiming specific performance against JT of his clause 3.3 obligation, then Iconic must show that it has always been ready and willing to perform its obligations. That's core page 92. And the Forrest case was a case cited by Iconic at first instance. So that's the basis on which the preliminary issues were decided. So that's why I say, although it may not be the optimum outcome, that probably the best outcome in my submission is for the Court of Appeal to answer the preliminary issue and then remit the matter.
That was not a case where the other party was in repudiatory breach, was it?
I can't remember now without checking. We just haven't had this argument is the reality.
But the formulation of the preliminary issues assumed that issue 3 was relevant
Yes,
to the claim for a specific performance.
It was
So
obviously done on the basis that if they weren't ready and willing, we would have a knockout blow in relation to specific performance.
Yeah.
That's how we have always understood it. And that's how the judge was proceeding as per 38. So I can't argue now a new point about whether that really is the test, or but the commercial court could decide that, along with any abuse argument that we run, that they shouldn't be allowed to change their position.
All right, that's your position.
Can
Mr.
I
Green.
just say that there's a slight complication here, because in addition to the preliminary issue pleadings, there are other pleadings, there are principal pleadings in the commercial court which are not before the court. And in those pleadings, the position that we have taken is, even if we are wrong on effectively on preliminary issue 2, even if we weren't ready on the repayment date, we are nevertheless entitled to specific performance for exactly this reason. So it is still there as a matter of the issues between the parties. So even if the court were to find against us on preliminary issue 2, then this broader point that is raised by Snell is there on the pleadings and is a matter that will be resolved by the court in due course.
Was that on the pleadings at the time the preliminary issues were formulated?
No, it wasn't.
And was it on the pleadings at the time that the preliminary issue was decided by the judge?
No, it wasn't.
So your position is the same as Mr. Davis? We should decide the issue as formulated?
My lord, yes. Well, my junior says alternatively you could hear submissions on this point, but I don't think any of us are in a position to do that in a comprehensive way.
No, I'm not sure it's really open to us to do so. Speaking from
So-
myself,
so-
it's not.
Can I just explore it a tiny bit more? Because one concern I have is whether if the Davis and Spalding position is correct, is it really right to say, and therefore at the time of completion, the innocent party doesn't have to go through all of the, as it were, the charade of demonstrating that they were ready, willing and able? Is it then really right to say that if they don't do that, they're not ready, willing and able? In other words, could that point throw some light on the question as at the completion date? Because what the passage seems to say is that in these kind of circumstances, the person doesn't have to make themselves available for completion, as it were. And so I just wonder whether this point does throw some light on the question as at the completion date. Because this term ready, willing and able is really ultimately to do with whether a party should or should not be allowed to get specific performance. That's the ultimate target of all of this.
Yeah, I mean, what I would say, my lord, in relation to that is assuming it is right is unfair on our side in the sense that we haven't been able to,
No, I know.
we haven't had the argument, and if it's not actually right, then it wouldn't inform anything. So I'm sure you see the point. I mean, in my submission, it wouldn't be right to have regard to this without it having been argued out whether it's correct or not.
Show the word outside. Show the word outside. We'll just rise for a moment.
Those in favour? All rise if able.
What we would like to consider doing, and this is something obviously on which you'll need to take instructions, and we'll hear from you as to whether it's what should or shouldn't take place. But for the reasons we've identified, we think the current position on Ground 2 is rather unsatisfactory in terms of what this court is being asked to decide and on the basis of the arguments. What we think might usefully be done is that we will decide Ground 1. So far as Ground 2 is concerned, we would contemplate adjourning the appeal, inviting you to go back to the commercial court and inviting the court to decide, firstly, whether the Snell point, if we can call it that, is open to Iconic. Secondly, whether, if so, it's right. And thirdly, whether, if so, the court can usefully address the consequences, either by proceeding to determine the specific performance claim itself, or alternatively by making a finding on another formulated issue as to readiness and willingness at a date subsequent to the repayment date, whether that be the date on which the court is then considering it or prospectively. And then if that course is taken, then depending on the findings, it would be open for the unsuccessful party to seek to challenge them by seeking permission to appeal. And if granted, that can come back to this court. It can come back together with the restored Ground 2, if still relevant. And we would envisage reserving all questions of costs on Ground 2 to await the outcome. So that at the moment seems to us to be a more satisfactory way of proceeding in order to decide what may be the real issue between the parties. And we are ourselves rather reluctant to give a judgment on an issue which may be formulated in a way which doesn't reflect the right question. So we say that to you. We'll give you a little time for you to A, consider it, and B, take instructions on it. If we say 10 minutes in the first instance, but if you need longer than that, then let us know.
All rise if able.
We're just going to try and speak to the client, so that's where we are.
It's what?
No, we don't have much choice.
Yeah, I mean, the reality is if the Court of Appeal saying we don't want to decide this issue, we want to decide whether we want to deal with it or not. Obviously, I think we've just got to deal with it. I think this is... I think the reality is we probably we've got the share certificate. Let's work that out afterwards. Can you imagine how bad it's going to look for them tactically if they terminate you now?
Yeah, okay, but that would solve the issue. Well, I wouldn't know. I guess.
I don't think
Can you argue that if you breached it?
no, this is the difficulty.
Yeah.
Exactly, that's
I'm not sure without. This comes back to the base. That's another wage duration. It's not a two-stage thing.
do you get some sort of undertaking by them that there'll be neither party will take the step? Or we might want to, yeah. Well, we certainly want to ask for details about the relevant thing to bear in mind.
No.
Yeah, no, we hear that. So do we ask, should we ask the court, should we say yes, it seems to us that's a very sensible approach. Could we have an order for an expedition? Summary judgment is respectable again. This is righteous. Also, it is on the defence. Well, subject to his defence to the bottom. Yeah, but this is just one. Is it what he says that if he loses this on ground 2 or reform through ground 2? It's a standard expression. That has to be determined anyway. So if that can be well done, I can't ask them. No. You should mention it. That's what we will do. I don't think I'm going to mention that. No, but what you do on this expedition. Yeah, I think we should do that. Yeah. Disagree with your expedition is that they say the expedition is only when they're in a conjunction application to hold the ring. We say actually no, we got the face on an expedition. They say if they appeal, so if they appeal, that's true. Expedition
No one's here.
They're not here. They're still thinking about it.
Okay.
Do you know if do they give any indication they might be coming back anytime soon?
No idea. Do they want to come back in, the OJs?
Oh, they are.
Only to ask if ours are ready.
Are you ready?
Yes.
Okay, we'll go and.
Do you mind?
No, that's fine.
Thank
Sorry,
you.
have we gone beyond our 10 minutes?
No. We were just sorry. Not at all. Not at all. They're happy to wait for a bit longer if you.
No, we're both ready.
Okay. Well, opening.
Court rise if able.
Shall I go first? Well, also, we are happy with the proposal that you have come up with. The one thing we would ask the court to do is to make, as far as possible, an order for this matter to be expedited in the commercial court.
My immediate reaction, I speak only for myself, is that that's a matter for the commercial court.
Perhaps if the court could give some indication as to whether or not it would be desirable, but I don't wish to push any further.
Why do you say it's desirable?
Well, just as this matter, just as today was ordered on an expedited basis, so it'd be good to bring this to a resolution on an expedited basis.
That's because there were junctions floating around.
Well, there still are, and still will be. I mean, there are still undertakings that are ongoing. So I think exactly the same reasons that applied when the application for permission to appeal was made still apply. But Lords, I don't wish to push it any
Did
further.
I make an order for expedition?
Sorry?
Did I make an order for expedition?
I believe so, yes.
Right, Mr. Davis, what's your
Can
position?
I say, expedition, we think we submit that would be better left to the commercial court because there's a defence based on misrepresentation. They've made a summary judgment application recently, and you haven't seen any of this because it's not relevant to the appeal. And we're now envisaging a new set of issues being combined with all of that. So how that all interrelates and how it's going to be managed is a complex question which you don't have full information on, really, because it's all taking place beyond your visibility. So it'd be better left to the commercial court. On the fundamental question of the proposed way forward, we don't object either. I just want to say, for the record, as it were, that we formally reserve our position on abuse of process, on whether there was in fact a repudiatory breach, and on the issue of Premier League approval, and what was and was not approved in the McCormack email, and whether that included approval of any option of the option agreement. I just want to say we reserve our position on all of that for later.
All right, well, we will take that course, and we think it's important that an order is drawn up now. We can announce the result on ground one, which will come as no surprise to you in the light of the way the hearing has gone. So the order will reflect that the appeal will be dismissed on ground one for reasons which will be given in due course in a reserved judgment. Ground two will be adjourned on the terms we have identified. We don't think it's appropriate to give any directions ourselves as to expedition. That will all be a matter for the commercial court. And if you would kindly agree the terms of an order and submit it to us, if it emerges that there is any slight disagreement about the exact terms in which you give effect to what I think we're all agreed should happen, then we can resolve it on paper.
And it's all costs reserved, as I understand it.
All costs reserved.
Including in relation to ground one.
Well, two things. The costs of ground one, you can address us on this, but we provisionally think that they ought to be dealt with now, and that the respondents ought to have the costs of ground one on which they've succeeded. We say that because if they're lumped in with reserved costs, it's conceivable that those reserve costs will not come back to this this court. But we'll hear you on that question.
Yeah.
Before I forget it, the other point, which Justice Phillips has rightly pointed out, is that we ought to extend the time for seeking permission to appeal from our decision on ground one until 28 days after you have the written reasons for our decision.
Just on the costs, we say your first instinct was correct, because obviously one fundamental point really, which is we may end up being the overall victors. And these were two alternative knockout blows, if you like, in our favour, and we only had to win on one of them to defeat the specific performance claim. So our route to complete victory is still alive. So in those circumstances, the costs issue, we would say, should be also kept alive by being reserved, or possibly related to the commercial court insofar as that's possible, but certainly not decided now against us when we may emerge fully victorious.
They appealed on the point, they lost on the point, I wasn't even called on the point. It must be we're entitled to our costs now on the point.
Well, just one point on that. I mean, obviously, if we had emerged from the appeal having won, certainly as this whole process was envisaged before the exchanges this afternoon, having won, lost on ground one, but won on ground two, that would have been a knockout blow to the specific performance claim, and therefore we would say we would be the successful party, and we still may, and therefore entitled to our costs, with perhaps a reduction for the reason that we lost on ground one.
I understand.
So we say that should be kept alive in fairness to us. We may emerge as the successful party.
Thank you. No, we think the respondents should have the costs on ground one. They're completely discrete points, as is apparent from the way the case has gone. We thought the point was bad, and that's the order we think is the fair one in relation to that. So would you please draw the order? I should say, because we always say it when we are reserving judgment, when it comes to the reasons on ground one, you'll get a draft in the usual way. You're aware, but please make sure that everybody who needs to know is aware of the dire consequences of not complying with the embargo, and it'll be the usual provision. Minor typographical or administrative errors to be corrected, no re-arguing, and no need to attend on handout. Anything else? Is there a transcript of this hearing?
I think we were going to request one. There's no transcriber here. No sort of privately provided one.
All right. If you procure a transcript for your own purposes, please could it be supplied to the court?
Yes.
Thank you very much. Thank you very much.
4 ayes in favour.